Welcome to a rebroadcast of Miranda Warnings. In April 2024, the New York State Court of Appeals overturned the criminal conviction of Harvey Weinstein in a 4-3 ruling. In September of 2020, following Weinstein's conviction, the members of his defense team appeared on Miranda Warnings to discuss the case and their plans for appeal. At that time, Miranda Warnings also spoke with attorneys representing plaintiffs in a civil lawsuit against Weinstein. Please listen again to the legal strategy regarding the case against Harvey Weinstein. You have the right to remain listening. Welcome to the New York State Bar Association's Miranda Warnings, where we debate, discuss, and dive into law-related issues important to all of us. I'm Dave Miranda, past president of the New York State Bar Association and partner at the intellectual property law firm of Heslin, Rothenberg, Farley, and Massey. We're here today on Miranda Warnings with the Honorable Barry Kamins and Arthur Idela, who are partners at Idela, Bertuna, and Kamins in New York City. They were part of the defense team that represented Harvey Weinstein. And they're going to give us some insights into what it was like to represent one of the most notorious and despised criminal defendants in recent history. Welcome, Judge Kamins, and welcome, Arthur.
Thank you, David, for having us.
Yes, thank you, sir. It's an honor and a pleasure.
It's great to have you, and I'm just going to give a little bit of background for each of you. Judge Kamins is a retired New York State Supreme Court judge, former assistant district attorney from Brooklyn, past president of the New York City Bar, and adjunct professor of criminal law at Brooklyn Law School. And Arthur Idela is a former senior assistant district attorney from Brooklyn, a legal analyst at Fox News, and in private practice has served as counsel to Fox CEO Roger Ailes, New York Giants Hall of Famer Lawrence Taylor, and real estate developer Abe Hirschfeld. He also served as past president of the Brooklyn Bar Association. So, both of you are well-respected criminal defense counsel. Obviously, most of your criminal clients are either criminals or accused criminals. But Harvey Weinstein, Vanity Fair wrote an article that said, who would represent Harvey Weinstein? And the answer is you two. So tell us about how that happened.
Well, I will tell you that my partner here, Judge Kamins, was not exactly jumping out of his shoes to represent Harvey Weinstein. I was connected to Mr. Weinstein through a friend, Jose Baez, who was representing Harvey at the time and said he needed local counsel. And I had known Jose from actually working on television and through our mutual friend, Geraldo Rivera. And so Jose and I met, and he said, look, I just need someone who knows, the courthouse and the ins and outs of New York City practice. So I want to bring you in. And then I had to go meet Mr. Weinstein in his little office in Midtown Manhattan. And David, the best way I could describe that meeting is two dogs walking up to each other in the park and sniffing each other out and trying to figure out, what they're all about. But obviously the meeting went pretty well. And then I went back to the office and told Judge Kamins and the rest of the team that we were being seriously considered to represent Harvey. And I would like to say that Judge Kamins gave it some pause. Would that be accurate, Judge Kamins?
I would say pause is a good word. I think my reluctance had to do in part because I anticipated what I knew would happen, that the media frenzy would be of such magnitude that it would be very difficult to try this case in New York City. And as you know, we tried to move it. We made a motion for change of venue, but that was denied. But I just anticipated the frenzy and the magnitude of coverage was so overwhelming, or would be so overwhelming. It would be very difficult. And that's why it was good to have this team effort, because no one lawyer could possibly handle this trial. So we had, as Arthur will explain, we had this team that was put together, including two attorneys from Chicago.
Yeah, I want to talk about the various roles that each of you played, but before we get to that, I want to just talk a little. This is a legal podcast. I want to talk about the impact on your practice. I mean, when you were going to represent Harvey Weinstein, did you have clients leave and say, look, we love you guys, but we can't be associated with lawyers that represent Harvey Weinstein? Did you lose clients because of it?
I know of one very high-profile client that we were about to represent. We actually had done some preliminary things for him, but we hadn't engaged fully with him. And there was a question mark whether or not that was going to happen, whether he was going to engage our services fully. And he's another name that's in the news that is a household name. And I knew, it was one or the other. I knew, if we signed up with Harvey, this gentleman was not going to retain us. But it was more than that. It was more about the reputation of the firm. And David, as you started off, Harvey was really the most vilified defendant in the modern era. And the person who I really turned to, because when you run a firm the way we do, and there's a lot of mouths to feed and a lot of people who are paying their mortgage based on the income that comes in from the law firm, you feel a tremendous responsibility to make sure you don't do anything that's going to put those people's lives and their livelihoods in jeopardy. So I did struggle with it a little bit. And the person who I really went to for the final vote was my father, who was a criminal defense attorney for 55 years and handled some really tough hombres, so to speak. And I said, Dad, what do you think? I mean, is this going to be a problem? And I'm a little concerned that he, without even batting an eye, he just said to me, let me ask you one question. Are you going to get paid? I said, yes, I'm going to get paid. He said, well, what kind of law do you think you practice? I mean, we practice in general a type of law where we represent people who are charged with horrible things, and rapes and murders and robberies and things that really alter people's lives. He said, you're there to protect the Constitution. You're there to protect our system of justice. And as long as, you're going to always do everything the way you always do, which is ethically, of course you should represent him. And so for me, that was, once I got the stamp of approval from Dad, it was all hands on deck. Then what happened was, in a nutshell, Mr. Baez and Mr. Weinstein didn't really see eye to eye on several issues. And Mr. Baez wound up, departing the case. And I asked Jose, I said, look, you brought me in. If you want me to leave with you, I will. And he was a real sweetheart about it. He said, absolutely not. He's like, if you can use this to, help Mr. Weinstein and help yourself, then you should definitely stay on board. And Mr. Weinstein was very focused on having a strong female participant on the team. And he found Donna Rotuno, and we met with her, Judge Kamens and I, several times, and we found her to be besides a wonderful person, a very accomplished attorney, a talented attorney. And she came on board, and then she brought her associate, Damon Chironis, with us, who's a young man who's incredibly gifted as a lawyer. And that was basically the team, was Donna and Damon, myself, Judge Kamens, and another woman from our law firm, Diana Fabi Sampson, who, as well as Judge Kamens, has an enormous amount of appellate experience. And having those appellate lawyers sitting at a table while you're trying a case is an experience I've never had before. And boy, is it a luxury.
So you had a defense team, and each of you had different roles. So why don't you share with me, at least for the two of you, what your roles were? Judge Kamens, what was your role on this defense team?
Well, as Arthur mentioned, it's always good to have somebody with appellate practice on the team, because there were issues that came up. I won't go into any great specifics because, as you know, it's the matter's on appeal right now. But things would come up. Certainly during the voir dire, a very significant issue came up, and research had to be done immediately. And we were able to complete some motions, as we in real time as we're going along with regard to a certain juror. So my role really was sort of to ferret out some legal issues as we were going forward and raise them with the judge. Diana Sampson also was a part of that effort to try to work on some legal issues. Of course, Arthur and the Chicago attorneys were there more as advocates in the courtroom, doing the cross-examination, the summations, the opening statement. So I think that's how it broke down.
So you mentioned voir dire. What was your thought process going into voir dire? What were you looking for in jurors?
Judge, you could answer that question.
No, I think Arthur was there picking the jurors, so maybe Arthur, you ought to.
I mean, look, it was really hard, David. It wasn't there. Nobody fell into an exact demographic, that we wanted. It was really more of an individual decision, literally juror by juror. We didn't have okay, this is exactly the person we want. And that's where, and the judge talks about issues of voir dire. I mean, that's where the judge really handcuffed us. I don't want to exaggerate, but I believe there were 20 potential jurors he would put in the box, and he gave us 15 minutes to speak to them. So if my math is correct, that's somewhere around 40 seconds per juror to speak with. That is not an enormous amount of time. Now,
it takes Arthur 15 minutes to say good morning sometimes.
Right. I mean, there was, to be fair, there was a questionnaire. So, we kind of knew their background. We knew where they grew up and whether they were married and how many kids they had. But we couldn't really address any of the issues of the day, quote unquote, because there wasn't enough time. So kind of what we needed to do was, after reading their questionnaires and then hearing the prosecutors, their 15 minutes, the round that I did, I narrowed it down. I'm like, all right, these 10 people are viable. Those other 10 people, for whatever reason, are not viable. So let me just take, 40 seconds and I'll double it. And at least I'll have 2 minutes with 10 people. But it was very hard, and that was a decision that the judge made, which was, in my opinion, very unreasonable. There was no reason to give both sides on a case of this magnitude when an individual who's never been charged with a crime in his life, who's facing life in prison, why he gave 15 minutes. It's just so those of you who don't practice in New York who are listening, that's not typical. 15 minutes in this type of a case with 20 jurors in the box. Maybe if there's 12 jurors in the box, 15 minutes, it's a little bit more manageable. But typically, at least on a homicide, a judge is going to give you double that amount of time, like a half an hour for the first round. So it was, and that, look, in my opinion, David, that's the most important part of the case is jury selection. As my grandmother told me, if you don't start with good tomatoes to make the Sunday sauce, it doesn't matter what you put in there, it's never going to be a good Sunday sauce. It's the same thing. If you start off with jurors who are just bent against you from the beginning, it doesn't matter how good your evidence is. If in their mind, they're like, well, I'm never saying not guilty. So that was an area that we will definitely be focusing very strongly on appeal. And, there's an issue that's all over the newspaper that one of the jurors wrote a book having to do with very similar subject matters. And that's going to be our lead issue on the appeal, is that there was a person on the jury who really should not have been on the jury.
And
they wrote the book before they were on the jury?
They were writing the book. The book was being written, and there were galleys being written while this juror was being questioned. But I just want to give some context. Picking a jury is difficult enough, but when you have jurors walking into a courtroom where they're walking past a ton of reporters, and in addition to reporters, protesters. There were groups of people protesting for various causes standing outside 100 Center Street. And these are the groups that the jurors were walking by. And as the jurors were sitting in the courtroom, the windows were open at 100 Center Street. The ventilation is terrible. And the windows were open, and they were hearing chants, calling Mr. Weinstein certain names. So that was the sort of the atmosphere in which Arthur had and the other lawyers had to try to pick fair and impartial jurors, which you can imagine was made much more difficult.
And David, David, if I'm sorry, but just to give you some, so we're not being crybabies. When I tried the Lawrence Taylor case in federal court, that judge, because of who Lawrence Taylor was and the publicity that case got, which was a fraction of the publicity this case got, she did individual voir dire. We basically spoke to one juror at a time about what they knew about the case and how what they had read and what they had heard was going to affect them in the case. And that's exactly what should have been done here. I mean, so 2 books had been written about this case by authors before it came out. There were at least two documentaries. The day that we're picking the jury, David, he gets charged in Los Angeles with new crimes. It's on the cover of every newspaper in the jury room before these jurors are walking in to claim that they're going to be fair and impartial, and yet the judge gave us 15 minutes for 20 jurors. It's just, it was not the nicest way I could say it. It just was not fair.
Now, at the beginning of the trial, you got your defense team actually made a motion to have the judge who tried the case step down, arguing that in some of the preliminary hearings that he showed bias against your client, something involving, I think, your client's use of a cell phone. What was the strategy in making that motion, which was ultimately unsuccessful?
Well, before the trial started, the trial started in January. In December, the judge called us in. I actually was the one from our team, and he said, "I don't want to see Mr. Weinstein's cell phone during the course of the trial." And that message was conveyed. And apparently, because I wasn't late for the court appearance, but I was late to miss this part. Apparently, Mr. Weinstein got to court early that day, and the judge was not on the bench. The jury wasn't there. The courtroom had not been assembled. And apparently, during that period of time, he took out his phone. It may have been he took it out just to shut off all of the, to shut it down. Well, somebody ran inside and told the judge, Mr. Weinstein's got his phone out. So, David, I walk into the court. I literally have my hat and coat on. Took my hat off walking into the courtroom. The judge takes the bench. He barely got us to put our notice of appearance on the record. And he says, "Mr. Aidala, tell me why I shouldn't remand your client right now for defying the court's order." I just look up. I have no idea what he's talking about. And I told him that. And then he asked another person on the team, and they didn't know what he was talking about. And then he's like, "Well, it's come to my attention. He had his phone out." And the judge just lambasted all of us. And he told Mr. Weinstein something along the lines of, "Is this how you want to start spending the rest of your life in jail?" Now, this is before the case has even started. And the judge is making comments about sentencing. And even what the sentence is going to be, right? You're going to start spending the rest of your life in jail. And the judge at that point had just been flexing his muscles to such a degree that we thought was unfair. From a strategy point of view, we thought, number one, we needed to protect the record, to let the appellate division to know how egregious this whole thing was. And sure enough, it was reported in all the papers. That's another reason why. So all the jurors are reading that the judge is telling him, "You're going to spend the rest of your life in jail." And number two, from a strategic point of view, I think we wanted to, fire a shot over the bow and say, "Look, Judge, you could beat us up all you want, but we're just not going to take it lying down. You may win every battle, but we're going to go down swinging."
Yeah, as you can imagine, it wasn't the best way to start a case. But I think, as Arthur said, and as you said, David, the judge was flexing his muscles, and I think it was the defense wanted to show that it was flexing its muscles too, even though we knew that motion wouldn't be granted. But sometimes it's just good to send a signal to the judge that we're watching carefully, and we'll make any appropriate motions we have to as we go forward in this trial.
Now, I want to talk a little bit about some of the strategies that you had in the case, to the extent that you can talk about them. This was obviously, the facts of the case are certainly well known. This was an interesting case in that there was no physical or forensic evidence that were involved. Turned the trial over really into a battle of credibility. And the prosecutors in the case portrayed Mr. Weinstein as a predator who kept his victims close after attacking them in an effort to control them, using his power over their careers to attempt to silence them. What was the defense strategy in going into this trial?
Well, it was never to say "Oh, this never happened" or "These acts never took place." It was always to say that they were consensual, and what we had to back that up is none of these were one-time encounters. So he got convicted, basically on two different women. Both of those women he had long-standing relationship with after the assaults. So, in Mr. Weinstein's defense was, look at all of the emails and the text messages that the complaining witnesses are sending to Mr. Weinstein almost immediately after the encounter that they're describing as being unwanted and unsolicited. One woman going as far as, I can't wait for you to meet my mother. She's coming into town. I want us all to get together. Writing another time, I heard you were in my neighborhood and you didn't come and find me. Why didn't you? I wanted to see you. These are all texts and emails that were sent to him after the date that they say they were assaulted by him. So there was that type of evidence in his favor showing that, in a very, schoolyard term, it seemed like there were no hard feelings between them because, and I'm not talking, David, that these relationships went on for like a week. I'm talking about they went on for years. And, you talked about it was a issue of credibility. Well, the judge also handcuffed us and Mr. Weinstein regarding credibility because he ruled in pretrial motions that if Mr. Weinstein testified, the prosecutors could ask him about, I don't know, Barry, I lost count, 22, 25 prior bad acts.
I think it was 25.
In the world that we live in, David, a prior bad act is usually, at the very least, an arrest or a conviction. They're talking about, they were going to let him get into like every argument he had with his secretary, every argument he had with his first assistant, that he punched his own brother in the nose over a fight. By the time they went through all 25 things, even though they were all petty, none of them had to do with an arrest or a criminal act. Nobody would have believed anything that came out of this man's mouth. And it was just so beyond the pale. I mean, Sandoval rulings usually a prosecutor could talk about 2-3 things. 25 just basically said, okay, Mr. Weinstein, now you can't testify. So the judge made the decision for the defendant that I'm not allowing you to testify because I'm going to make you sound like a lying devil before you say a word to this jury.
I want to talk about that decision about having the defendant testify. But before we get to that, I do want to go a little deeper into, the strategy that you had here. You talked about the fact that some of these or the cases that were involved were continued relationships. But as you know, better than I, certainly, legally and factually, a continued contact doesn't nullify a rape accusation. In fact, long-term relationships can include sexual abuse, and unfortunately, sometimes they do. So the fact that there was continued conduct here legally wouldn't necessarily change the ultimate result, which in fact in this case it didn't. So there would have to be more than that. And it was actually, David, if I may correct you, it actually did. Because don't forget, I mean, no one is declaring this as a victory for Mr. Weinstein, but he was charged with six crimes. He was convicted of 2. They found him not guilty. They found him not guilty of 4. And a lot of that has to do with what I said, which was the people's, the complaining witnesses' actions thereafter, what they did and what they failed to do, like how long they waited to report the crime. And as I said, there were all these emails from them about, their feelings towards Mr. Weinstein. I mean, one of the women, she basically had like a semi-nervous breakdown during cross-examination. And I don't use that term lightly. The prosecutor had to leave the stand. The prosecutor overnight flew her mother in from California. She testified the next day squeezing a therapy ball that was visible to all of us. And that was all due to her being cross-examined on all of her emails and all of her texts. So, how could it be true that you testified on direct examination that you hated him and you despised him from the day that this alleged, to the day that this attack, as you describe it, took place? How could
how could it be true that you despised him and you couldn't stand him when you wrote him this email and this text and this email and this text? And isn't it true you saw him on this day in this hotel and you had consensual relations with him? It isn't true you saw him on that day and you had consensual relations with him? And they did, even on that person, they found him not guilty of one of the charges and guilty of the lowest charge. That's the one he's only doing, I think it's 3 years on. So, to some degree, and again, David, I'm not living in a dream here. No one is saying Mr. Weinstein getting sentenced to 23 years is a victory, but our strategy on 4 of the 6 counts worked. And the one that people know that they call him a rapist. He actually was convicted on the lowest rape count, and that's the one he's doing 3 years on. The count that he's doing 20 years on is it's a sodomy count, a criminal sex act that did not involve any actual sex. So it was tough. We did the best that we could with what we had. I still will go back to our beginning of our conversation, jury selection, because there are a lot of jurors out there and potential jurors out there and people who I meet on the street that, number one, say it just doesn't ring true to them that someone would be so upset about what took place and then continue the relationship. And you know what? We're not talking about women who were really in the industry, like Gwyneth Paltrow or anyone, and they were going to lose their position. We're talking about one woman was a hairdresser and another woman didn't even really work in the field. So, it was difficult for the prosecutor to say, well, if they denied him, he was going to wreck their lives, because he wasn't really involved in their lives. And I'm going to say it again. I mean, he was found not guilty of 4 of the 6 counts. So the jury must have believed some of our strategy. It was just really the one woman who testified that he assaulted her in her home that they did not. That was the big conviction that the judge sentenced him to 20 years on. And a lot of people think that 20-year sentence is quite excessive based on other sentences that judge have given to other men who had no criminal records charged with the exact same crime.
Right. And of course, this is why we have defense counsel, even for the most despised criminal defendants. And in fact, especially for those that are under public scrutiny, so that the charges that are brought against them are fairly heard. And of course, the defense here did, as you said, everything they could to defend their client, which is obviously appropriate in our system of justice. The counts that amongst the counts that he was in fact acquitted of were included being a sexual predator. And even though he was acquitted on those charges, they did serve a purpose in the trial, because by bringing the charge of being a sexual predator, they had to show that this was part of a continuous practice. And to do that, they were able to, or had to, bring in testimony from several other women, and obviously there were many, that said he was engaging in this kind of conduct with him. And certainly that must have had a tremendous impact on the other counts that you were defending as well. I don't see how you could separate those in the same trial.
Well, to say there wasn't a spillover effect would be naive. He was acquitted of all of those counts. Rose McGowan was the big complaining victim there, and they acquitted him on her counts. And that was really, in my opinion, that was really piling on, because, and it was a political play to do this, predatory sex act, because at Mr. Weinstein's age, what could have happened is exactly what did happen, right? So even if you eliminate those things, he still is basically serving life in prison. The DA's office just wanted those words, and they knew they were in front of a judge that would have done it. Had he got convicted of that, he would have given him life in prison. There's not a doubt in my mind. He wanted to grab the headlines. The prosecutors wanted to grab the headlines, and it just sounds, sexy, life in prison, as opposed to giving a 70-year-old man, 23 years, which, basically he'll be out maybe for his 90th birthday. So, yes, that was another battle we had to fight. And, the time, effort, energy, the motion practice, the preparation to deal with that whole segment of the case obviously pulled us away from everything else that needed to be done with the two primary complaining witnesses. And just so you know, David, the judge allowed so much corroboration into the case. I shouldn't say corroboration, Molyneux rule evidence, which the Judge Campbell will explain what that is, but an extraordinary amount of Molyneux evidence was presented to this jury compared to any other trial, not only that I've tried, but everyone around me. I mean, obviously, Judge Cameron and I know a few lawyers in the New York City legal community, and when they heard how many witnesses were going to be testifying on top of the actual complaining witnesses, everybody was just blown away. Judge Cameron, could you just tell them what Molyneux evidence is?
The Molyneux issue has to do with, is part of the prosecution's direct case. This is not on cross-examination. This is part of the people's direct case that prior bad acts can come in to which the prosecutor claims is relevant to an issue in the case. And this was a critical part of the people's case and one of the issues that we will undoubtedly address on appeal. But that makes the defense attorney's job even more difficult, because in addition to trying to attack the credibility of the complaining witnesses, you have to try to attack the veracity of prior bad acts, which really have nothing to do with in a sense, with the actual crimes for which the defendant is being tried. So this is an issue that, as you know, that came up in the Bill Cosby case, which is now on direct appeal. And this is an issue that came up in our case, and we'll be addressing it on appeal.
Well, obviously, oftentimes, and the two of you know better than I do, that in a typical case, it will come down to an issue of credibility of the witness, and you can. That's part of a defense. But when you have a case like this, and you talk about Bill Cosby as well, when you have literally dozens of people coming forward and say this person engaged in similar conduct, it's awfully hard to say that they're all lying.
Well, you're raising an issue that sounds like propensity. And that's exactly what is not supposed to be allowed at a trial. The prosecutor is not permitted to introduce evidence that shows a propensity of the defendant to act in a certain way. The only way Molyneux evidence can come in is if it is relevant to a particular issue. And that's one of the arguments we made. It was not relevant to any issues that the prosecutor was trying to establish. So again, you're right. If a juror hears that in the past somebody has committed similar acts, you're absolutely right. They're going to think that this defendant committed the current act. But that's not the way the system's supposed to work. The system's not supposed to allow a defendant to be convicted based upon his, quote, propensity to commit certain types of acts.
Now, you had an opportunity to have Harvey Weinstein testify in this case. He said publicly that he wanted to testify, knowing, I'm assuming, everything that you told him about what he was going to be asked about. Can you talk a little bit about the decision to not have him testify?
Well, without getting into obviously the discussions we had with him, I mean,
of course,
he did want to testify, but we discussed with him the nature of the Sandoval ruling that was made, which Arthur mentioned before. And when you think about it, if a person wants to tell his or her story and get on the stand, but knows in advance that the district attorney is going to be allowed to cross-examine him about 25 prior bad acts, you have to think twice about whether you want to get on the stand, and that's essentially what Mr. Weinstein had to do. He had to decide whether he could get on the stand and be believed by the jury if they heard about 25 incidents, not necessarily crimes, but incidents, arguments, minor altercations, verbal disputes, things like that. And he had to make a decision. His ultimate decision was that he chose not to testify.
I mean, David, these are seasoned prosecutors. I don't think I'm exaggerating. They probably would have had him on the stand for the first full day of his cross-examination, just testifying about those 25 things. So after, we would put him on the stand and he would tell his version of the events, and that, everything was consensual and these were the nature of the relationship with them and the dinner parties they went to together and how they came to his house and he went to their house and he met them all. And he would have painted this picture of two young women who he had, great long-term relationships with on many levels, not just sexual, friendship-wise, intellectual-wise, et cetera, et cetera. And then the prosecutor stood up, and for a day, she literally would have gone through 25 different things that would just, not portray him as someone who was credible, even if you can't have a trial within a trial. So why did you punch your brother in the nose? Well, how far is the judge going to get into the fact that these are two brothers and blah, 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 and how they grew up? And so, it's very hard. As I said, David, I've only heard, Sandoval rulings. Okay, a prosecutor into 2 or 3 issues in the past, and usually it's a prior arrest or a prior conviction. Here, it was just every little parking infraction that he had was going to be brought out. So it was a difficult decision. I know it was for him, because when you believe that you didn't do anything wrong, you want to tell everybody that. And I'll just do a little sidestep. Our current client is Alan Dershowitz. We can't stop him from telling the world that he didn't do anything wrong with anybody in Jeffrey Epstein's world. As much as we say, Alan, we appreciate you didn't do that. He's like, look, I didn't do this. And to my last dying breath, he said this on the courthouse steps, I will say it till the day I die. And then when I die, my wife will say it. And when my wife says it, my daughter will say it. And then my grandchildren will say it. I never did anything wrong, blah, 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 blah. So there was a degree that Mr. Weinstein wanted to have that opportunity to tell the world he didn't do anything wrong. But ultimately the judge, we did have about a half an hour to sit in the back. And obviously we spoke about it endlessly in our office. And that was the decision that Mr. Weinstein ultimately made. Whether it was the right one or wrong one, we'll never know. But right. Yeah, obviously, when you get convicted, you're thinking, well, maybe he could have talked his way out of it, but, he could have talked his way into it, or, you'll never know.
Right. Now, you mentioned the Sandoval ruling that was going to permit all these numerous prior bad acts. Is that part of the basis for your appeal?
Well, Sandoval rulings generally are a balancing act. The judge has to balance the right of the people to be able to cross-examine as opposed to giving the defendant a fair opportunity to testify. And it will be part of our appeal in terms of the judge, whether the judge stepped over boundaries here and rendered a decision which was not fair to the defendant. So I won't go into anything more, but it will be part of our appeal, yes.
So just as logistically, the appeal has not been filed yet?
No, the appeal has not been filed yet, and we're working on it. And as you know, Mr. Weinstein is, well, you may not know, he's up in Buffalo right now. As a matter of fact, he has a court date this Friday with regard to the Los Angeles matter. Los Angeles has now begun extradition proceedings to bring him out there. And he has an attorney who will be representing him in Buffalo on Friday to address the extradition proceedings.
Well, Arthur Idella and Judge Barry Kamins, I want to thank you very much for being with us here on Miranda Warnings and sharing some details about the strategy of the case and this very famous case. Obviously the issues that we're talking about here are very serious and significant. But we do have something of a lighthearted feature here on Miranda Warnings called Music, Book, or Movie. And I'm going to let each of you share with us something that's helping you get through this quarantine for our listeners.
With me, it's definitely music. That's a new great.
What are you listening to, Arthur?
Well, and I'm a diehard Rolling Stones fan, and they wrote this crazy song called Ghost Town a year ago, and then they tweaked it a little bit because basically that's what New York City turned into during the pandemic. So, and I was supposed to go see them, David, in Cleveland, and Geraldo Rivera was going to take me backstage and introduce me to the band because he knows them so well, and maybe go have a drink with them in the Rock and Roll Hall of Fame. Of course, that all went sideways. So yeah, I'm going back to my childhood roots and letting the Stones get me through this interesting time.
Well, I lead a more sheltered life, David, and I listen to jazz. And there's a great station in New York, WBGO. I listen to jazz a lot while I'm working on Sandoval motions. So that's the sheltered life that I live in.
Well, whatever you need to do to get the juices flowing, Judge.
Yes, thank you, David. And if you have any suggestions, I'd welcome them.
I know you live a sheltered life. I know the Stones wrote "Give Me Shelter," so that might be an entree for you.
Okay, thank you.
So thank you both, Arthur Aidala and Judge Kamens, for being with us on Miranda Warnings.
Thank you.
Thank you, David. Thank you very much.
Thanks for listening to Miranda Warnings. I encourage you to rate, review, and subscribe to Miranda Warnings, a NYSBA podcast, available on the Apple Podcast app, Spotify, Google Play, or wherever you get your podcasts.